Welcome back to Organize, the Business Law Breakdown. I'm your host, Professor Seth C. Oranburg, and today we're diving into the world of damages and remedies in contract law. Have you ever wondered what happens when someone wins a contract lawsuit? How does the court decide what's fair compensation for an injured party? Well, I'll give you the punchline. The standard measure of contract remedies is called expectation damages. Is that what you expected? Well, it's what we'll explore in this episode. In our last episode, we discussed how parties can modify or discharge their contractual obligations through mutual agreement. Today, we're shifting gears to look what happens when one party fails to hold up their end of the bargain and loses a lawsuit about it. By the end of this episode, you'll understand the ins and outs of expectation damages, including direct and indirect damages, and the limits, the foreseeability limits, courts place on these awards. But before we dive into details, let's put three key takeaways at top of mind. Expectation damages aim to put the injured party in the position they would be in had the contract been fulfilled. So they're forward-looking, hence the word expectation. They're about giving the party what they expected from the deal. No more, no less. You'll understand the difference between losses that flow directly from the breach and those that are more remote and might not be part of the expectation interest. And you'll see how courts use concepts like foreseeability to limit excessive damages awards. So if you've ever been curious about how the law quantifies broken promises, or how business can protect themselves, or at least know what to expect when deals go south, stay tuned. We're about to unravel the world of contract remedies, starting with its major thread, expectation damages. So let's talk about some of the key concepts in expectation damages. Expectation damages, as mentioned, are the primary remedy in contract law because the goal of contract law is for promises to be fulfilled. So the goal of contract damages is to put the injured party in the position they would have been in had the promises to them been fully performed and had they also done their part. So you get the benefit of the bargain, what you expected from the deal. This aligns with the core purpose of contract law. The core purpose of contract law is protecting the expectation interests of the parties. Basically, contract law exists so that people can rely on promises. So what do you get when contract law needs to step in? You get the value of the promise. There are two main types of expectation damages that are added together. And the reason we keep them separate is one of them is going to be awarded routinely and one maybe more speculative. But you get them both. You get both direct and indirect damages. Direct damages are losses that flow directly and immediately from the breach. So if a seller fails to deliver goods, direct damages would be the value of the goods. Now, you were also going to pay something for the goods, so you might subtract out the price you're going to pay. And how do you know the value of the goods? Well, the market price might tell you the value of those goods, and you were going to pay some amount. We'd call that the contract price. And if there's a difference, then you get the difference, because then you can take that money and go to the market and buy those goods, and there are no more direct damage to you. You're just as well off as if you had got them in the first place. Well, you're not entirely all that well off because you also have to go to the market and you have to potentially sue for these damages, and you might have to advertise and find a new supplier, which is where indirect damages come in. Indirect damages are losses that are more remote but are still proximately caused by the breach. We don't talk about proximate causation in contracts nearly as much as you do in torts. Torts is the proximate causation area of the law to really hone in on this subject. But the idea of proximation is that not all things are reasonably related enough. If you draw a long enough line, you can connect almost any dots. But law will cut that line at a reasonable point, and that has to do with the proximity doctrine. More about that in our sessions on torts. Now, we can further break down indirect damages into two subcategories, and the reason these subcategories, again, are helpful conceptually is because one of them is easier to find than the other. Let me put it this way. Incidental damages, a type of indirect damages, are costs incurred by the injured party in dealing with the breach. So if you have undelivered goods that are not, that you need to store for longer, because a shipper breached their contract with you, the cost of storing those goods may be an indirect cost of the breach of the shipper. You also get the direct damage that you didn't get the value of the shipment, but you also had to pay to hold the goods. That's indirect, and it only happened because the shipper didn't pick the stuff up. Or you might have to find a replacement shipper, and so you have to go and place an advertisement, or you have to spend a few hours of your time interviewing people to figure it out. That's probably a incidental damage. That is an indirect type of damage, and it's incidental, it's incident to, and it arises from the breach. Then we have what are called consequential damages. So consequential damages are a type of indirect damages that are more remote losses. And here we have things like lost profits or damage to business reputation. And consequential damages are kind of a placeholder for saying, I'm not sure if they were reasonably foreseeable and proximate. So consequential damages are an area where we generally get into some debate on whether they apply. If they do, we add them to our damages calculation. If they don't, obviously they don't come in. So that's kind of where the action is doctrinally, is what consequential damages would count or not. It's crucial to understand the court's place limitations on expectation damages. And the most important limitation is the limitation of foreseeability, which stems from the famous case of Hadley v. Baxendale, which we'll break down today. The rule states that damages must be reasonably foreseeable at the time the contract was made if they are to be available in breach. And again, we'll talk about that later in the episode. Another key principle at the front end is the duty to mitigate damages. Now, it's not an affirmative duty per se, but the rule basically states that you can't collect damages that you would have been able to mitigate. So you kind of have a duty to mitigate, to reduce, get rid of certain damages, to avoid certain harms, if you want to end up getting paid in the end of it. So if you have some undelivered food, you might have to pay to store it in a refrigerator so that it doesn't spoil, because if it's spoiled, it would be lost and damaged. And so it might be cheaper to keep it in a refrigerator than to let it rot on the street. And you may have an obligation to do that if those goods have some value. So we'll get into some issues of duty to mitigate damages, because if the injured party does not take reasonable steps to minimize their own losses, their damages may be reduced. And it's just a way of incentivizing people to take care. Finally, it's worth noting that expectation damages are not the only remedy available. In some cases, courts will award what are called reliance damages, which actually is backwards looking. So at the beginning, we said expectation damages, as you can imagine from the name, is about the expectation interest, what you thought you would get if the deal were performed. The amount of benefit you get minus the amount of cost that you would incur is your expected benefit from the contract. That's your expectation interest. On the other hand, sometimes it's hard to know that. And courts will look back and apply reliance damages, which will put you back in the position you were had the contract never been formed. We'll talk about that in the future. Courts might also apply what's called the restitution interest. Restitution and unjust enrichment is an entire doctrine. It's an entire area of law with its own restatement, but it comes up in contract law because contract law will prevent unjust enrichment. If someone has been unjustly enriched because of a contract, they may have to disgorge that amount or return a specific thing. And again, we'll talk about those alternative damages later. Understanding these concepts is crucial for anyone involved in contracts, because you have to understand the end of the game to know how to play the beginning. These damages figures shape how courts approach breach of contract, and so they significantly impact the outcome of legal proceedings on contracts and should inform how you negotiate as well. Let's break down a landmark case regarding the limit to money damages in contract law. It's called Hadley v. Baxendale. It's from 1854. This case established a crucial principle for determining consequential damages in breach of contracts cases. The facts are as follows. Hadley owned a mill in England. The mill's crankshaft broke, causing the mill to stop operating. Hadley contracted with Baxendale, a carrier, a shipper, to transport the broken crankshaft back to the manufacturer in Greenwich, England for repairs. Baxendale promised to deliver the shaft, quote, without delay. But due to Baxendale's negligence, the delivery was delayed, and it was the shipper's fault. As a result of the delays, Hadley's mill didn't work for longer than expected. He only expected to be out of business for the time that it would take to ship the crankshaft and get a new one. But he was out of business for longer because Baxendale was maybe taking a nap. This caused Hadley to lose additional profits, and Hadley sued Baxendale for those lost profits. And those lost profits are a type of consequential damage which may or may not be included. And that's what this case is about. Whether Baxendale should be liable for Hadley's lost profits due to the delay in delivery. Now, we already know the delay in delivery was Baxendale's fault. So we're not even worried about fault here. But even if breach of contract is your fault, you're not responsible for damages that were not foreseeable, not reasonably foreseeable. And the court ruled in favor of Baxendale, the shipper, stating that damages recoverable in breach of contract should be 1, those arising naturally from the breach itself. We call those direct expectation damages, or 2, those that may reasonably supposed to have been in the contemplation of both parties at the time they made the contract. Now, this is roughly indirect damages and what we now call consequential damages that are foreseeable. The court didn't really break those two concepts apart like we do today. The court instead reasoned that Baxendale could not have known the mill would be inoperable without the specific shaft. Most reasonable mill operators had a spare, apparently. It was possible, for instance, that Hadley had this spare, or the mill could have been stopped for some other reason. Maybe that while the shaft was broken, Hadley went on vacation to France. I don't know. Since Hadley didn't communicate the special circumstance to Baxendale, the court held the lost profits were not recoverable. And the case established 2 important and sustained principles of law. 1, the foreseeability rule. The foreseeability rule holds that damages must be reasonably foreseeable at the time of contract formation to be recoverable in the event of a breach. And 2, the importance of communication. If a party wants to recover special damages, they must communicate the special circumstances to the other party at the time of contracting, in large part because you may not take the deal. If you were asked to ship something, you may not do it if any delay would cost billions of dollars of loss you'd be responsible for. So if you want someone to take on that responsibility and risk, you got to tell them up front. The Hadley v. Baxendale rule has been widely adopted and remains a fundamental principle in contract law. And you can find it today, roughly speaking, in the Restatement Second of Contracts at Section 351. It's also incorporated into the Uniform Commercial Code. The key takeaway is that parties to a contract should communicate clearly about specific circumstances and potential losses, allowing both parties to assess the risks involved and the price they're willing to pay and charge. Let's explore a what if that illustrates the foreseeability principle established in Hadley v. Baxendale. Imagine Tech Gadgets, an e-commerce business, orders 1,000 units of a new smartphone model from Gadget Maker for their upcoming Talktober sale, a company-specific event that happens in October. Gadget Maker fails to deliver the 1,000 smartphones on time, causing Tech Gadgets to be unable to have its Techtober sale. Can Tech Gadgets claim lost profits as damages? Well, first off, Tech Gadgets can get damages, right? Because we know that there was a promise to deliver. They didn't do it. That's a breach. So what are the damages? Generally, expectation interest. So one of those is the direct damages. The direct damages would be the contract price and the market price difference. So if Tech Gadgets got a good deal from Gadget Maker and bought the smartphone model for less than the market price, less than they could get it if they covered, if they went somewhere else, we know that's part of the direct damages. But what about the delay? What about the lost profits because they had a sale during that time that they couldn't fulfill? Well, it's unlikely that with these facts, Tech Gadgets could recover lost profits. The Techtober sale is company specific. I mean, I certainly never heard of it before. I literally just made it up for this podcast. So it's not something Gadget Maker would necessarily know about or anticipate. The lost profits from this particular sale would probably be considered unenforceable, unforeseeable consequential damages. Now, let's say that Tech Gadgets had told Gadget Maker that the smartphones were for his Techtober sale. explained that its biggest sale event of the year was in October, and the reason why time is of the essence in delivery was because they needed it because they were promising to fill their orders promptly. Would this change their outcome? Well, yes, this is exactly the situation where Tech Gadgets has communicated the special circumstances to Gadget Maker. And since Gadget Maker was actually aware, not just foreseeably aware, actually aware of the importance of on-time delivery, then now the lost profits would likely be considered foreseeable and thus recoverable under the Hadley principle. Third, what if instead of a company-specific Techtober sale, the smartphones were supposed to be delivered for Cyber Monday, which happens right after Thanksgiving. And now Gadget Maker failed to deliver on time so that Tech Gadgets wasn't able to participate in Cyber Monday, and as a result, lost out on sales. Now, even if Tech Gadgets hadn't explicitly mentioned its interest in sales on Cyber Monday, could it get lost profits? This is testing the limits of the foreseeability principle. Cyber Monday is obviously a well-known major shopping event in the e-commerce world. It's even bigger than Black Friday, and it's clearly known in a world where you have suppliers of gadgets. So a reasonable supplier in Gadget Maker's position should be aware, and Gadget Maker probably was actually aware, that failing to participate in Cyber Monday may result in lost profits. However, on the other hand, Gadget Maker might think, Tech Gadgets doesn't need the product on hand in order to participate in the sale, and if they're 1 or 2 days late, they can fulfill the orders later. Without specific communication from Tech Gadgets, a court could find either way, really, that the lost profits may have been foreseeable and recoverable, or maybe not. These scenarios highlight how the foreseeability principle operates in practice, and they highlight the importance of communication in contracts because parties need to get involved in risk they expect. The role of industry knowledge, common practice, and the parties' communications will change how the court rules. The key takeaway is that the more foreseeable the consequence of a breach, the more likely that the non-breaching party can recover for those consequences. Now let's break it down with another landmark case in contract law. A little more recent, this is PV House versus Garland Coal and Mining Company from 1962. This case illustrates the principle of economic waste in calculating damages. So Willie and Lucille PV House leased their farm to Garland Coal and Mining Company so Garland could conduct a strip mining operation on some of their farmland that wasn't useful for anything else. They weren't actually farming on that portion of the land. It wasn't fertile, so they instead leased it so that Garland Coal and Mining could come in and conduct a strip mine. And just by the way, strip mining is really destructive. It's going to obviously cause huge gashes in the land as they extract all the minerals. Now, the lease included a provision that required Garland to perform restoration on the land after the mining operations were complete, so I guess it wasn't so gashed and lumpy. Garland mined the coal out of the land, but never performed the restoration work. So the PV Houses sued. They were unhappy that they only got paid for the lease, but they didn't actually get a nice-looking flat farmland anymore. They had a strip-mined farmland that wasn't restored, and they wanted to sue for the value of the restoration work, which was $29,000 in 1962. This is something like $300,000 or so of value today. However, the restoration would only increase the market value of the property by about $300 because this wasn't very valuable land. This was land that wasn't useful for anything. So the court had to decide what's the proper measure of damages. Was it the cost of the restoration or the diminution in the value? So we go back to this idea of expectation. On the one hand, the PV Houses argued that what they expected was nice, flat farmland, and what they got was bumpy, strip-mined farmland. But what Garland Coal argued was that what the PV House expected was farmland worth $300, and they got farmland worth $0. So restoring the land is $29,000, but the land itself was only worth $300. How much do you have to pay when you don't do what you promised? The Supreme Court considered two competing principles. One is the general rule that damages for breach of contract should put the injured party in the position they would have been in had the contract been performed. In general, contract damages meet the expectation interest. Two, the principle that courts should avoid economic waste when awarding damages. So let's ask a question here. What do you think the PV houses would do with the $29,000? If you had $300,000 today and you had 100 acres of farmland on which some of it was bumpy, would you spend your $300,000 flattening it again? Well, the court thought probably not, and recognized that applying the first principle would, although the first principle, meaning the principle that we should put the party in the position it would have been in and the contract been performed, would in some ways require the full cost of restoration. On the other hand, to give them what they really bargained for, they would only need the increase in the property value. The court held the cost of performance is so grossly disproportionate to the benefit received that the contract provision is just incidental to the main purpose of the contract. The PV houses didn't really care about having not so bumpy land. And the thought experiment here, which I don't think they actually conducted because, people lie if you ask them, but if you gave the PV houses the money, did they spend it on flattening the land? Or would they, go on a vacation or something? And since no one reasonably would spend that kind of money restoring this useless land to flat and not strip mined, the court decided not to award those damages. So PV House established the principle that courts should consider economic waste when calculating expectation damages. And this prevents overcompensation in cases where the cost of performance far exceeds the value gained. The decision attempts to balance the sanctity of contracts with practical economic considerations. And look, the ruling has been criticized. It potentially allows parties to breach contracts where it's economically beneficial, undermining the principle that agreements must be kept. It has influenced how courts approach damages, despite its criticism. So, while Hadley focused on the foreseeability as a limit of consequential damages, PV House deals with the appropriate measure of direct damages in the first place. Both cases demonstrate the court's effort to limit potentially excessive damages in contract cases, reminding us that in contracts cases, we're just trying to give you the economic benefit you expected, not more. The PV House decision underscores that expectation damages are not always a straightforward calculation either. Courts may consider the economic realities of a situation, balancing the need to enforce contracts with the desire to avoid economically wasteful remedies. And so it highlights the complexity of determining appropriate damages in contract law, where long-term agreements or those involving significant changes to property that's hard to value haven't been performed. And it does remind us that the purpose of contract remedies is not to punish anyone. It's just to compensate the non-breaching party for their loss so people get what they expected. Let's look at a lighthearted pop culture reference that illustrates this. The 2023 film Tetris offers an illustration of expectation damages and foreseeability in contract law. It's particularly interesting in the context of intellectual property rights. In this movie, Hank Rogers, a Dutch video game designer, believes he has secured the console rights from Tetris from a British software company named Microsoft. Remember that game with the blocks? Yeah, they think it's going to be a big hit on Game Boy later. However, Rogers later discovers Microsoft didn't actually have the rights to sell. They actually belonged to a Soviet agency, ELORG, I guess. The scenario sets up a perfect potential claim for expectation damages because there was clearly a breach. Microsoft, the British company, promised to sell Hank Rogers, the game designer, some rights to a particular piece of intellectual property for the game Tetris, but they didn't have them to sell, and so they clearly breached that promise. Hank could argue that his loss was the expected profit from distributing Tetris on consoles and potentially even the value of promoting Game Boy, which launched with Tetris as its launch game. By the way, Game Boy was a big deal. It's not clear that Microsoft, however, prevented him from realizing those profits in a foreseeable way. The foreseeability principle from Hadley v. Baxendale comes into play here. Microsoft, what did they reasonably foresee at the time of contracting, right? That's the measuring time. That's what matters. Could Microsoft have reasonably foreseen the extent of Rogers' potential losses? The movie suggests that Rogers had plans to partner with Nintendo to release Tetris on the Game Boy, and it could lead to massive profits. But unless Rogers communicated those specific plans, such extensive damages would be considered unenforceable. They weren't reasonably foreseeable. Moreover, think about it. Rogers probably wouldn't communicate that to Microsoft. If you were Microsoft and Rogers said to you, I really need these rights because I could make $1 billion with them, you might ask for more money. So there's actually a reason he didn't communicate this information. In fact, maybe Microsoft could even have gone to Nintendo themselves to try to sell the game. It's actually sometimes quite negative to tell your contracting party about exactly the kind of gains you expect from a deal because they might try to extract some of that value. So the film illustrates how the foreseeability principle can limit expectation damages. And while a party could claim enormous profits from a potential release, a court would probably limit the recovery only to the damages that were reasonably foreseeable to the other party, the breaching party, at the time of the agreement. Since there wasn't even a Game Boy out there, it'd be hard to imagine that they would have survived the losses from that. This example from the Tetris movie demonstrates how complex business dealings, especially in emerging technologies, intersect with fundamental contract law principles like expectation damages and foreseeability. So let's recap the main points from this episode. Expectation damages are the primary remedy in contract law. They are based on the expectation interest. They're future-looking, and they aim to put the injured party in the position they would be in had the contract been performed or fulfilled. There are two main types of expectation damages. You add them together to get your total damages: direct damages, which flow immediately from the breach, and indirect damages, which flow approximately from the breach, which include what we call incidental and consequential damages. The Hadley v. Baxendale case established the foreseeability principle for consequential damages, stating that damages must be reasonably foreseeable at the time of contract formation to be recoverable. And the PV House case demonstrated that courts may limit damages to avoid economic waste, even if it means awarding less than the cost of contract performance. They may instead only offer the amount of contract lost value. Courts place various limitations on expectation damages, including the requirement of foreseeability, the duty to mitigate damages, and the principle of avoiding economic waste. And in applying these principles, courts consider factors such as the nature of the contract, the foreseeability of the damage, and the economic realities of the situation. Understanding these concepts is crucial for anyone involved in contract negotiation or disputes because they should shape how you approach what you ask for in the deal. As we wrap up this episode on expectation damages, how about contracts in your own life? How might the principle of expectation damages and foreseeability apply if one of these contracts are breached? So if you're preparing for exams, one way to think about this is create your own hypothetical based on the Hadley v. Baxendale principle. How would changing a small detail in a scenario affect the foreseeability of damages? Or for professionals, consider reviewing your current contracts. Are there any potential consequences of breach that you might explicitly communicate to your counterparty to make sure that they're considered foreseeable? Are there any consequences of breach that you deliberately didn't talk about with the counterparty as a negotiation strategy? Or if you're on the other end where you owe some obligation to a party under a contract, would you imagine any situation where they try to collect a huge amount of damages from you for a situation you couldn't or wouldn't necessarily foresee? Now you're aware of these issues, you can start to address them. So if you found this episode helpful, please subscribe to the Organized podcast and leave us a review. Your support helps us continue to break down complex legal topics for students and professionals alike. Don't forget to join us for our next episode, where we'll be diving into the world of reliance and restitution damages. We'll explore why courts might award these alternative forms of damages instead of expectation damages. And hint, not always possible to see the future. Remember, understanding these concepts isn't just about passing exams, it's about being prepared to better navigate the complex world of contracts in your personal and professional life. So that's all for today's episode of Organized, the Business Law Breakdown. I'm Seth C. Oranburg, and I thank you for tuning in and exploring the intricacies of expectation damages with me today. I hope you found it informative and helpful, and remember, until next time, keep your agreement strong and your argument stronger.